your hometown news and information station.
Welcome back. With us now is Laurie Hall and Bill Jones. We are talking about alternatives to litigation in family law cases. So we've kind of laid out how collaborative law works and how mediation works. And I guess I think one difference that may not necessarily be clear is collaborative law is sort of a longer process, it seems, than mediation. And all. What are, I guess I just need you guys sort of counterpoint as to what the benefits are of the collaborative law and what the benefits are of the mediation. And I know they overlap some, so we may want to talk about that too, and I'll start off with Laurie on that.
Okay, well, collaborative law is a longer process. The attorneys are committed along with the parties to work as long as it takes to reach a settlement on all issues. Typically in mediation, you're there for a day. You might go back to the mediator and schedule a follow-up with the mediator, but it's more confined, whereas collaborative law is over a longer period of time, and the parties do have, they don't have the pressure of time hanging over them to resolve their issues. That helps. So in that way, it is different. Yes, the parties do really need to resolve all of the issues in order to stay with their collaborative attorneys. However, once you're down to one or two issues, it's very motivational to know that that your alternative is to go and hire a different lawyer and have to run to court and essentially start over unless you resolve the case. So whereas it might be seen as some sort of con against collaborative law, it's also a huge motivating factor getting the parties to settle the case.
Okay, and I guess one question I've had with collaborative law is if you come to a point to where there's an impasse and you know it's not going to go forward, but you've got some consensus on it, can you enter into an agreement that would limit the issues for the litigation?
Absolutely. For instance, if you resolved your issues related to parenting, but alimony remained an issue or division of assets remained an issue, you could still commit to a parenting plan and then deal with the other issues in court, or vice versa. If you resolve the issues with assets and debts and spousal support, if it was involved, but you couldn't resolve your parenting issues, then you could sign a marital dissolution agreement and then go to court on the remaining issues. Okay,
and Bill, as far as with the mediation, that's sort of what are
yeah,
what
I mean,
looking at there?
Both collaborative law and mediation relatively are new, or at the very least they're newer to this area. I know collaborative law is it's really making a push here in the Memphis area. Mediation's been around a little bit longer. Again, this is something the parties can do without attorneys on the front end. So when you talk about it being quicker, generally that's the frame of reference where it's faster if the parties go to the mediator before they hire attorneys. If you hire attorneys and then go to see a mediator, I don't know necessarily that the process is going to be any quicker than it would with collaborative law, because at that point mediation is just one aspect of your divorce process where discovery and fact-finding will occur before you ever get to that mediation table. One of the strengths I see in mediation, again, is if there are these 2 or 3 big key issues that you can't come to an agreement on, if you cannot come to an agreement on those, you can draft a mediation agreement just saying what portion you will agree to, have your same attorney that's been with you throughout the process, and they can carry that forward in a courtroom setting. Where is that's a positive, that can also be a negative, because I think in collaborative law, when you see that all that's on the line, you may be more motivated to settle, whereas in a mediation setting, if you really want grandma's full-length mirror, you can just stop the whole ordeal and throw it all out the window over that one little thing and go forward. So you get to keep your attorney in mediation. The mediator's a disinterested party. They try and give you the power to make your own decision, which is what I think both do. Both try and take the decision-making process out of the hands of the court and put it with you and your family where they should reside. Both are valuable tools.
Now, one question that comes to mind with me is, in divorce cases now, I think statutorily it has to be attempted to have been mediated before it can go to a hearing or a trial if it is a contested divorce. Now, the question that rings in my head is, if a family goes to a mediator prior to filing a divorce, or there's mediation that takes place during the collaborative law process, does that count once something is filed with a court as to whether or not the mediation prong has been met for it to be able to go to a hearing?
Sure. I think if you can ethically report to the court that either you or your clients attempted this process, that's enough to fulfill that requirement. Some judges in our jurisdiction actually will forego that if the attorneys report to them that no matter what we do, it's not going to happen. Okay. But it's something that should be attempted in all cases.
Yeah, and as far as in the collaborative law, is that the same case?
Same. I think as long as the attorneys that have taken it to the litigation approach report to the court, and of course, the Rule 31 mediator would submit the report as well to confirm that, then that prong has been satisfied.
Okay. Our time is up for this edition of Legalese. I would like to thank our guests for taking time out of their busy schedules to be with us and sharing their thoughts and insights. If you'd like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I am Vince Perryman. Thank you for watching.